Ready, start. These three appeals arise from the common judgment of the learned single judge in WP in bracket C numbers 36631 of 2018. The writ petitioner colleges, which were all established in the self-financing sector in 2001/2002 for imparting technical education and were affiliated to the MG University and the Calicut University respectively in the state of Kerala, were automatically affiliated to the APJ Abdul Kalam Technological University in bracket hereinafter referred to as the Technological University, which came into being through the APJ Abdul Kalam Technological University Act 2015, hereinafter referred to as the 2015 Act. The university can affiliate any of the engineering colleges or institutions imparting education in technology owned by the Government of Kerala or government controlled societies, private aided and private unaided self financing educational agencies which before the date of commencement of this act remained affiliated to the different universities except deemed universities in the state of Kerala, provided they meet the criteria prescribed under this act, ordinance and statutes for affiliation WA numbers 968, including but not confined to the availability of the faculty, administrative machinery, infrastructure in bracket buildings, laboratories, etc., which will be laid down by the university from time to time under the provisions of this act. The affiliation of such institutions to other universities in the state except deemed universities shall stand transferred to the university on and from the date of commencement of this act. It can be seen from a perusal of section 60 in bracket 1 extracted above. Read with WA numbers 968, 1263 and 1269 oblique 2019. The definition of affiliated colleges under the Act, that the technological university could affiliate any engineering college or institution imparting education in technology, and whether owned by the government of Kerala or government controlled society, private aided and private unaided self-financing educational agencies which before the commencement of the 2015 Act with effect from 5/5/2014 remained affiliated to a different university except deemed university in the state of Kerala, provided the said colleges or institutions met the criteria prescribed under the 2015 Act, ordinance and statutes for affiliation. It is the submission of the learned senior counsel Sri Kurian George that a holistic reading of section 2C 60 and 63(3) of the 2015 Act would unambiguously indicate that once an institution college was found entitled for an automatic transfer of its erstwhile affiliation to the technological university under the 2015 Act, then the continuity of affiliation that was envisaged under section 61 of the Act could not be ignored for the purpose of section 63(3) of the same Act. The contention, in other words, is that the deemed affiliation that is envisaged in section 61 has to be recognized for all purposes under the 2015 Act, including for the purpose of reckoning the 6 years period of affiliation envisaged for the grant of permanent affiliation. Per contra, the learned counsel Sri K.R. Ganesh, appearing for the Technological University, would emphasize on the words used in section 63.3 of the WA numbers 968. On a consideration of the rival submissions, we find force in the contention of the learned senior counsel for the appellants, hearing that the affiliation of the appellant institutions to the MG University oblique Calicut University had also to be reckoned for the purposes of computing the 6 years affiliation that is required for the permanent affiliation under section 2015 Act.